Major breaking news involving the Second Amendment, but not really. Specifically, a win for gun rights, but not an obvious one. The United States Court of Appeals for the Third Circuit out of Delaware, Pennsylvania, and New Jersey has just issued a ruling in favor of LEOSA and retired law enforcement officers who are able to conceal carry nationwide. This does relate to you. Yes, you, even if you're not a police officer. I'm going to tell you how it all connects up, and you will hear this nowhere else, I promise. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Moxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, so major breaking news. The United States Court of Appeals for the Third Circuit out of Delaware, New Jersey, and Pennsylvania has issued a major ruling in a case called Federal Law Enforcement Officers versus the State of New Jersey. This case involves the application of a federal law known as LEOSA, which stands for the Law Enforcement Officer Safety Act, LEOSA, sometimes referred to as HR 218. As you may recall, under LEOSA, and if you're not a law enforcement agent or you're not formally law enforcement, this still may apply and help you. I will connect the dots in 1 minute. But matter of fact, LEOSA, as a matter of fact, is designed to allow active law enforcement officers, as well as retired law enforcement officers, if they satisfy certain criteria, to conceal carry their guns nationwide. It's actually a statutory precedent that's already on the books and has been for over a decade, constituting and allowing for nationwide concealed carry. Now, you have to be law enforcement or former law enforcement, retired. Now, I'm going to explain to you how we in the Second Amendment community may take advantage of this, but let's get to that in a moment. I just want to talk briefly about this federal law enforcement officers case, and then we'll go on to what it means for all of us. The case itself involved a debate about a conflict between LEOSA, which is a federal law enacted by Congress, against a more restrictive New Jersey law to try to restrict the ability of retired New Jersey police officers from concealed carrying in the state and arguably nationwide. Okay? So you have this tension here where it was easier for retired New Jersey police officers to conceal carry nationwide under the federal statute of LEOSA than it was to satisfy the New Jersey statute. So it's kind of this weird tension where if you're an out-of-state police officer carrying the gun in New Jersey, you're fine. But if you're a New Jersey retired police officer carrying the gun in New Jersey, you might be arrested and put in prison because the criteria was much more onerous to satisfy under New Jersey state law than it was under the federal law. So law enforcement officers, retired, and other organizations, including the New Jersey Fraternal Order of Police, brought this lawsuit against the state of New Jersey, saying that the New Jersey law that makes it harder for New Jersey retired police officers to carry is preempted, is federally preempted under the United States Constitution's Supremacy Clause, which says that if there's a conflict between federal law and state law, the federal law controls. It is supreme. That's called the Supremacy Clause. Now, when you get into court about which law controls, the federal law or state law, you get into the question of what's known as federal preemption. Federal preemption, and that is the notion of federal preemption says that if federal law covers the same topic that a state law does, the federal law preempts or supersedes the state law. And that is what this case was all about here, that the retired police officers in New Jersey sued the state of New Jersey saying that under LEOSA, they were allowed to conceal carry nationwide, including in New Jersey. And the state of New Jersey says, no, that's not the case. You have to comply with the New Jersey statute. And that was the fight. Whether or not the New Jersey statute could govern New Jersey retired police officers in terms of being allowed to conceal carry. Well, I'm happy to report that the U.S. Court of Appeals for the Third Circuit ruled that LEOSA, and this is a big deal for us, you'll see why in a minute, that LEOSA preempts state laws. To the contrary, specifically what the court wrote is as follows. They said, quote, "We conclude that LEOSA reflects Congress's clear and unambiguous intent to confer a right upon individual, basically qualified retired law enforcement officers, who comply with the statute's identification requirements to carry concealed firearm, LEOSA's text demonstrates that Congress's unmistakable focus was on the individual right holder. Congress used individual-centric language when it conferred a benefit upon an individual who is a qualified retired law enforcement officer and who is carrying the identification required by the statute. So that's very powerful language, which means that people, former law enforcement officers, and also active law enforcement officers have a right to sue under LEOSA if a state is violating their rights to concealed carry. Now, let's talk about what this might mean for you. So, first of all, it's always great to have more and more people carrying guns, as I see it, for public safety. And former law enforcement officers' concealed carry is helpful for several reasons. Just as a matter of public relations, in support of our desire to have nationwide concealed carry, where we can conceal carry anywhere we go in the country, or at least carry, it's very powerful to be able to say, well, why do law enforcement officers under LEOSA get to conceal carry nationwide with reciprocity, and we non-law enforcement officers, we ordinary Americans who aren't law enforcement, who are not retired law enforcement, why do they get to do it and not us? Especially when there's been no abuse of the system. So it's just a persuasion point when we argue for nationwide concealed carry as a general matter. So as a matter of rhetoric, it's good for us. It also is just good for us because the more people conceal carry nationwide, the more it becomes the norm, which I think it basically is in most places, including these blue states. But again, we have a lot more work to do. I think all that is positive, not just on a public relations point of view and a rhetorical point of view, but as a practical point of view of more people carrying nationwide, the more it becomes the norm, the better it is for the Second Amendment community all across the board. Okay? Now, here is the big idea I have. I've been toying with this for actually a while now, and I'm now going to talk about it on this channel. Here's the idea. Now, LEOSA, again, Law Enforcement Officer Safety Act, has been around for a while. To qualify for LEOSA, there are certain requirements that have to be met. You can either be a retired police officer or an active police officer. Now, there's a bunch of different ways this can be done, but if you are an active police officer or law enforcement in a particular state, now stick with me here, folks. If you're an active law enforcement officer in a particular state and you're employed in some capacity, you have the authority to arrest, the authority to carry a gun, and so on. There's a list of criteria there we don't need to go through in this video right now. Then you can carry nationwide under LEOSA, provided you have an identification card or a badge, presumably, something that indicates that you are active law enforcement or you are retired law enforcement and meet the various criteria that must be met. So here's the idea you're going to hear first here at the Four Boxes Diner, and that is this. Although the details might have to be worked out, there's no obvious reason why red states, Texas, Florida, the Carolinas, Oklahoma, Utah, I'll let you figure it out, good gun states, Idaho. It seems to me that those states could create a system of some sort where they deputized residents in Florida, Texas, Idaho, Montana, whatever, under state law, and converted the residents of that state, provided they went through some basic training, to become law enforcement agents in that state. So if you become a deputy police officer in the state of Florida, Texas, whatever, and this program that's set up by Governor DeSantis or Governor Abbott, Kristi Noem, you get the point. This deputized security force for the state could be set up so that it's specifically designed to satisfy the criteria set forth under federal law for those people who are either active law enforcement or retired law enforcement. Now, I don't think you necessarily have to be a full-time employee or law enforcement. You have to be law enforcement, active now, having met the criteria in your state. And if your state says, indeed, you are employed part-time, let's say, as a deputy in a sheriff's department or in the state defense department, whatever it happens to be, there's a lot of ways to get creative here. I'm not going to do all the legal work for all the states right here, right now. I'm sure they're capable of figuring this out once they get the idea. Then they can create essentially a reserve. I don't want to use the word militia, but metaphorically, it may not even be a bad idea like that. A state defense unit a state version of the National Guard, separate and apart from the National Guard that we talk about, and allow citizens in that state to volunteer and become part-time law enforcement officers in that state, qualified entirely with an eye towards satisfying the federal LEOSA statute. Once that were to occur, it would seem to me, conceptually, theoretically at least, that now, let's say I'm a deputy law enforcement officer in Texas or Idaho or Montana or the Dakotas. Now I've got my badge. Now I've got my photo ID that says I'm active law enforcement. Now I, as a resident of those states with those credentials, I can now conceal carry nationwide under the federal statute. And this federal decision in the Third Circuit Court of Appeals, assuming that were to be the law of the land, I know there's a conflict there involving the Fourth Circuit we won't get into right here about some of this. But assuming that's the law of the land, I would be able to conceal carry with my law enforcement ID and my badge nationwide. And if I were stopped in New York or New Jersey or California, I would be able to show that license as law enforcement, and under the federal statute, which preempts state laws, at least according to the Third Circuit Court of Appeals decision here, I would not be arrested. And not only could I not be arrested, to the extent that there's any inconsistent state laws, those state laws are, again, federally preempted by LEOSA. So again, this is an inchoate idea I've been thinking about. I think there's a lot of smart people that watch my channel, and you all in your states can probably take this idea and run with it and start connecting the dots in your states to find a way to deputize as many citizens, residents of your state as possible, issue them the photo ID described by the federal LEOSA statute, and voila, you'll be the most popular governor in America, because you will have found a way to allow your citizens of your state to conceal carry nationwide. Because Congress has already created a law allowing the nationwide reciprocal carrying of firearms, provided that you're an active law enforcement officer or a retired law enforcement officer. So if you meet that criteria under your state's law, it would seem to me you would be able to conceal carry nationwide. And I can tell you, I'm confident that if I sat down and tried to figure this out, if I were a deputy attorney general in some state, I feel I could find a way to make this work. But again, you have good lawyers out there in your states. I'm sure you can find some to think about this and to take my idea and see if there's a way to execute upon it. So there you have it. So again, bottom line is this big win at the Third Circuit Court of Appeals. I'll put a link to the decision down below. Good job if you want to carry a gun, if you're former law enforcement. A great win for you. Nationwide concealed carry. But it may just set a precedent that we all can benefit from if we happen to live in a state with some creative governors, with good attorney generals and smart lawyers that can figure this out. The idea that I just articulated and how to execute upon it. So there you have it. All right, folks, hope you learned a little bit something here today. Hope this wasn't too geeky. Don't forget to follow me on X at 4Boxes Diner. I tweet stuff out several times throughout the day in addition to my Second Amendment information here. So you may want to check that out, X at 4Boxes Diner. And we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.